Today is February 15, 2012. This is the last session where we talk about the issues raised in Learning Module 2. And when we last met, I was talking about the hypothetical in your text, that is Professor Meyer's Chapter 2 account of Roger Redden's experience in being charged with incest or sexual abuse of a child. And I explained to you that there is a investigation and then later there's an arrest, and I said that one of the first events that happens after an arrest is something called an arraignment, which usually happens within a day or two after someone's arrested. And that is a process whereby a criminal defendant is notified about the charges against them. That's a constitutional requirement. It is something that did not happen in England before the Revolution and the adoption of the United States Constitution in America. Often people were hauled away without knowing the charges, nor were they told the charges once they were imprisoned pending trial. Well, we don't stand for that in the U.S. There's a formal process where the charges are presented to you in detail. You also are advised at the arraignment of your constitutional rights. We learned that among those rights are the right to remain silent and the right to an attorney. The Fifth Amendment is the right to remain silent. The Sixth Amendment is the right to counsel. So after Roger Redden was arrested, he would go to this arraignment, this short hearing where the court would notify him of his rights and the charges that have been filed against him. Eventually that case would wind up being presented in New Jersey to a grand jury. I told you that a grand jury is neither grand nor a jury in the sense that they make a very simple decision, and that simple decision is whether there's enough evidence to move forward and have a trial in the case. It's another filter in the system. When Roger Redden was first arrested, they had to convince a municipal court judge or a local judge that there was probable cause, that this crime probably happened. That's the only standard. After that, there is a grand jury right in our state. And in many states, not all of them, but many states. And you appear before 23 citizens. It is a simple majority. And a simple majority decides whether there is probably a case here. And the case moves on for a trial before a petit jury. And I mentioned that last week as well. Petit being the more important of the juries, although the less grand sounding, because it uses the word petit or small. It simply means that there's less jurors. A smaller group of people make a decision, but it has to be unanimous. And if there's an acquittal in the criminal courts, a person cannot be tried again. We talked about all those things. Now I want to talk about some of the things in between that. A grand jury presentation, by the way, is only the prosecution. Only the prosecutor presents the evidence. The defendant doesn't have a right to testify. The accused doesn't have a right to testify. If there's really, really good evidence for the accused, the grand jury never hears it unless the prosecutor wants them to hear it. And while it may seem unfair, the purpose of the grand jury is simply to evaluate the best evidence that the state has. And if the state cannot convince 23 people that there ought to be a trial in the case with its best evidence, then it probably ought not go before a regular jury or a jury that decides guilt or innocence. So this is just an inquiry into whether there's good evidence available. It's not a mini trial. It's not an opportunity to hear all sides of the issue. Otherwise, what's the point of having a trial later on? You just need one trial then in front of the grand jury. That's not the role of the grand jury. So while some may perceive it as unfair, they do so because they misperceive the role of the grand jury. You need to think of it as another filter on the actions of the government. Yes, we take that complaint to a municipal judge. Yes, you have to swear it out and show that there's probable cause. But within 30 to 60 days, you go before another panel of regular people from the community in which this case arises, and they listen to it. And they can decide not to charge, they can decide to charge. So it's another filter. The only time you have to present evidence in New Jersey on behalf of the defendant is if there is evidence that, if true, makes it impossible for the defendant to have committed the crime. Even a child in an incest case who comes back later and says, my dad didn't touch me at night, I made it all up, is not dispositive in this state. Many prosecutors present that to grand juries, but a kid can come in and say that, and it could still be true. In fact, it happens a lot, where kids recant or retract or take back their allegations when in fact they were molested. So that's not dispositive. Now, if someone's accused of murdering somebody on the Little Falls side of Montclair State campus, and the prosecutor has a video recording of that person at a Los Angeles Dodgers San Diego Padres baseball game on the same day of the murder, you got to present that to the grand jury. Because the defendant, the accused, could not have been in Los Angeles and killed a man in Little Falls at the same time. It is an impossibility. It's dispositive. It's 100% exonerating, if that's true. If he was in L.A. and not in Little Falls, he didn't do it. So you have to tell that to a grand jury. But in between that and all kinds of evidence, there's plenty of stuff that doesn't have to be presented to the grand jury. In fact, it's very rare we present any evidence on behalf of an accused to the grand jury. Ever. Because you very rarely have that kind of dispositive stuff. And if you had that kind of dispositive stuff, why the heck would we be going to a grand jury anyway? We can connect the dots and prove he wasn't there. I mean, when we say we prosecutors have an obligation, so do deputies, attorney general in child maltreatment cases, to be honest and fair, to do what's right and to do what's true. Defense lawyers are a little bit different. Their role is a little bit different. But if we know the guy's in L.A. and the actions that he's accused of occurred in Little Falls, then we have to dismiss. I'm going to waste my time in front of a grand jury. Sometimes dispositive things happen, not so much in child abuse, but I gave you an example. A kid who says, I made it all up. It never really happened after they make a compelling disclosure against their father or their uncle or their mother or their sibling, somebody that they have tremendous loyalty towards. Well, sometimes we give that. We simply don't dismiss the charge because you don't buy it. Gang cases where there's gang assaults or gang murders and people come in and recant or confess to the crime, but we don't buy the confession. We may need to tell that to a grand jury. If there's a gang shooting on the corner of Jones and Mercer Streets, and we charge John Doe, and Mary Jane Doe comes in later and confesses and says, I killed the guy on the corner of Mercer Street. Well, if she did, and it was a one-person shooting, then he could have done it. Nevertheless, the government might go forward anyway. They put her confession before the grand jury, but they let the grand jury hear the whole case, including witness intimidation and whatever relationship there might be between the now confessing person and the person who's accused. So sometimes there are dispositive, or there are statements, or there is evidence that must be presented to a grand jury that, if true, would exonerate that person completely. Yet prosecutors move forward anyway because they don't buy it. That's different from the video of the guy in L.A. at the Dodger game. You know, how do you get around that. If that's true, he didn't do it. Got to let him go. I'm going to waste my time in a grand jury, yes.
Do all cases go before a grand jury, or are some of them clear-cut enough that they never have to go to a grand jury? They go straight to the regular petit jury?
Yeah, that's a good question, but in New Jersey, they all must go before a grand jury. Not every case does, because they're resolved before a grand jury. The attorneys and the litigants reach a plea bargain, and it doesn't go to grand juries. But absent a plea agreement, the matter goes to a grand jury. In every case. So you have Roger read in charge, you have an arraignment, you have a grand jury presentation, you have a petit jury trial, you have a requirement that it be a unanimous verdict. We talked about all that. I told you about the kinds of things that happen during the trial that the prosecutor tells, hopefully in a compelling way, in an engaging way, his or her version of what happened based upon the facts. The defense, when they open, they typically wrap themselves in the flag and talk about what a great country this is and don't mention the offense at all. That's good. That's good lawyering, and that's what they do. And then at the end, after all the witnesses testify, both parties get to say what they think about the evidence, what they call closing arguments, and then that jury makes a decision. Well, it was just suggested that maybe you don't have to go to grand jury. You do, but if there is a plea agreement, then you may not have to go to grand jury. And if you go to grand jury and someone is charged, in America and in New Jersey, we call that an indictment. When the grand jury says, you know what, we think there's enough, there ought to be a trial, there ought to be a petit jury trial. Well, when the grand jury says that, they issue an indictment, I-N-D-I-C-T-M-E-N-T, an indictment, also known as a bill, B-I-L-L of indictment. I think I mentioned that last week. It's just a leftover from another time. So when you get a bill of indictment, that means it's going to the next step, to the petit jury. A no bill means the grand jury decided there wasn't enough evidence and the case is not indicted. I also told you the prosecutor can go back again and again and again to the grand jury if there's no indictment. Same thing with a mistrial. I told you if the jurors in a petit jury trial, in a guilt or innocence trial, cannot agree, and the judge has to declare a mistrial, the prosecution can try again and again. It's only where there is an acquittal on the merits, where the jury or a judge hears the case and there's a finding of not guilty, that you cannot try a person a second or third time. It's over. Ex post facto, not ex post facto, double jeopardy. Double jeopardy is the legal concept that prevents that. It's a constitutional provision, not a legal concept. It's a part of the American and the New Jersey Constitution. Well, either before indictment or between indictment and that jury trial, there's going to be negotiations between the prosecution and the accused's lawyer to try to resolve the case. I have two cases now. I have them presented to the grand jury right now. One involves a doctor, Leonard Joachim, who I'm prosecuting for molesting a patient during an examination. And the other one involves a Passaic Valley High School teacher for having sexual contact with a student. Both of those cases, we made arrests in the last 3 or 4 months. Neither of those cases have I prepared for grand jury. In both of those cases, their attorneys have contacted me, and we are in negotiations about resolving those cases before I even go to a grand jury. And I know those attorneys want to talk, and they want to see what we might offer or what might be a good resolution. I don't want to have to go to a grand jury if I can help it. You know, it's work and a prepare. And post-indictment, after the indictment, you have the same kind of negotiations. It hasn't changed. Now, in the teacher case, we're developing some more evidence, but in the doctor case, that's the end of it. There's really no more evidence. We've investigated that the best we could. In any event, there are plea negotiations. Now, plea bargains have a bad reputation in some quarters, and some people think negatively about plea bargains, and that's not surprising. I mean, if you think about the law and you are someone who believes in the integrity of the system, you might say to yourself, well, wait a minute, if we go through all this trouble to pass laws and to say what the punishments are, when somebody breaks those laws, they ought to get the sentence that's written in the book of laws. Whatever the criminal code says, they ought to get punished. Why is there this kind of negotiation, this plea bargain stuff? Why should a guy get less than he's supposed to? Well, that's a legitimate question. But the law is not mechanical. It's not mathematical. It's not some equation in which you punch numbers in and there's an outcome. And then you issue the punishment. It doesn't work that way. The law involves the testimony and evidence arising from real people, from people's frail recollections, from people who have biases and motives and connections and loyalties. So whether somebody shot somebody, or whether someone molested a child, or whether somebody threw a brick through a jewelry store window and stole jewelry or not, is not a fact until you march people in who were there or near there at or about the time this stuff happened. And even that, in 2012, may not persuade some of these hard-scrabble jurors. You need to prove your case. And you need to prove it beyond a reasonable doubt. And that is easier said than done. So, plea bargaining exists despite its rather unfortunate name. Why is it unfortunate? Well, the word bargain, it's so mercantile, it's so commercial. It's the stuff of used car salesmen, not attorneys, not of the judiciary, not of the profession of the law. Bargaining. It just doesn't feel right, and I appreciate that. I'd like to call it plea compromise, or something like that, because I don't like the word bargain. It involves a negotiation, and it does involve a negotiation. But to compare it with the kind of negotiations that happen in a used car lot, or the haggling that goes on in a flea market, really demeans what we do. When I say we, what we do with the law. I mean, these are real people who suffered real injustices. And they ought not feel that their cases are treated like some trinket at a flea market on Route 18 in New Brunswick. That's not what it is. The system cares about them, but we can't prove every case. And here's the reasons why plea compromises continue to this day. There are 3 of them. And these 3 things are inherent in the system. They're part of the system. They can't be ignored, and they compel plea bargaining. There is not a jurisdiction from Maine to Florida, all the way up to the northwest corner of Washington State, right down to the Tijuana border where San Diego lie, that does not plea bargain. They tried to abolish it in the Bronx, New York. It was a sham. They still plea bargain there. They claimed they abolished plea bargaining, but instead they just dropped charges. You know, they consider plea bargaining, if you're facing 10 years, we're only giving you 7. So they did a roundabout form of plea bargaining by dismissing the Class A felony and having a plea to the Class B felony. That's plea bargaining. That was disingenuous. It was exposed as a sham rather quickly. If there's one place on the planet that could not abolish plea bargaining, it would be the Bronx, New York in the 1970s. There was lots of crime there. Lots of crime all over this country. Now, for some time, they did abolish plea bargaining in one of our less inhabited states, where one of the more conservative female politicians hails from, the state of Alaska. not a lot of people in Alaska, and comparatively not a lot of crime. So perhaps you might get away with it in Alaska, but it didn't even work there. There's plea bargaining everywhere. Why? Because there's too many cases. There's too many cases and not enough resources. If there were 10,000 prosecutors and 700 judges and 4,000 court reporters and 20,000 secretaries and clerical support, in some of these urban jurisdictions, you could try every case, but you can't. In any large jurisdiction, in the jurisdiction in which I'm standing, whether I'm in Essex County or Passaic County, doesn't matter. In both of those jurisdictions, on a Monday, on a typical Monday, a prosecutor walks into court and there's 20 to 25 cases on. Only one case can go to trial this week, right? Think about it. You got to pick a jury, you got to put evidence on, you have these openings, these closings, right? Jury's got to go in their room, think about it, come back with a verdict. The judge has to tell them what the law is. At least a week on any case. Criminal mischief on a stop sign. It's not a felony, but if it was, it'd take you the better part of a week in a modern jury trial. So the prosecutor walks into court with 25 cases, 20 cases, could only try one of them. You got 19 left over. But guess what? Crime didn't take a holiday. Next Monday, you got 20 other cases. You got to take those other 19, put them with the 20, you got 39, you got to spread the 39 over the next 3 weeks. Crime didn't take a holiday. Week 3, more crimes occurred. So, I'm overstating it, aren't I? There's lots of cases and not enough people. So, why does plea bargaining exist? Well, for one thing, it's efficient, right? It moves cases along. It may not be people's perception of the nobility of justice, but it's a very pragmatic and logical way to deal with cases. Plea bargaining survives in every state in this country because it's efficient. So that's the first reason why we have plea bargaining: efficiency. Efficiency. A related reason is economy. When I say economy, I mean not only the economy that comes with not having to try the case, not having to spend money bringing witnesses in and sequestering jurors and trying the case and doing all the stuff that makes up a trial. That's economic. Plea bargaining is efficient and it's economical. But I'm also talking about the economy of emotions, the economy of resolving a case on behalf of the victim and the suspect and the accused. Unfortunately, if someone gets arrested in 2012, his trial is not likely to be heard, if they want a jury trial, until 2014, maybe 2015. So we're running 2 to 3 years, and that's not in Essex County. God knows how many years it takes in Essex or Camden or Union County. But in Passaic County, we're looking at 2 or 3 years before your case goes to trial. If you're in jail, you may sit there for 2 years. If you're not in jail, your case could linger for 3.5 years.
Is that in juvenile court as well?
No, juvenile court has a whole bunch of different rules that apply. Their cases have to be moved swiftly, and they do, because they don't have juries either, so things can move a little more swiftly. It's the jury that, it drags it along. There's other facets and factors in the adult courts. But in the juvenile division, the dynamics are quite different. There's still plea bargaining there, and they couldn't try every juvenile case in order to try these cases within 30 to 45 days. But there are institutional requirements, there are rules and laws that require that you dispose of a juvenile case within certain time periods. And they're generally resolved within a couple of months at most. And if the lawyers want it to continue longer, especially the accused child's lawyer, the juvenile's lawyer, then it could take longer. Obviously, if he consents, it can take longer. But in the adult system, it could take a couple of years, maybe 3 years, depending upon the case, before the case is ever resolved. So what happens? You know, every Monday when those 20 to 25 cases are listed, a notice goes to the victim and their family. and to some of the witnesses and says, listen, this case is scheduled. And you could tell that victim and their mother and the other witnesses and everyone else associated with this case over and over again, take it easy, don't get excited, your case is not going until I tell you it goes. It doesn't matter, because every time that notice comes in the mail, their heart skips a beat or two, maybe more. Every time that notice comes in the mail, they think about what's about to unfold, about what's going on in their lives, about what might happen next week, about what he might say when he goes to court, about whether he's going to say he did it or not, about whether he's going to make me go into court and stand on the witness stand and tell my story, about whether my friends are going to find out if I go to court, about whether they're going to take my picture if I walk into the courtroom, about whether if he found not guilty, he's going to come and get me or hurt me. Every time a kid gets that notice, or their parent or caregiver, or somebody affiliated with that trial gets that notice, whatever their role is, they get anxious. Sometimes more anxious than others, but they get anxious. So there are emotions involved. We want to recognize it or not. And when I talk about efficiencies, when I talk about economy, by resolving it today, that stops, doesn't it? The kid don't have to worry about that anymore, do they? They don't. So plea bargaining is valuable. Plea bargaining brings efficiencies and economy, not only economic, money kind of economy, but it brings some peace to the child and the family and the participants in the prosecution. It is emotionally economic. To end today, which could drag on for 3 years, is emotionally economic. And it's in the interest of the victim and their family and the system and justice. It is justice. It's the best kind of justice. So plea bargaining is not a bad word. It's necessary. Well, as all bargains, they require both sides receive a benefit, right? When you go to the flea market, you go buy that piece of jewelry and you try to negotiate it to some price you can live with. The vendor's going to make some money. You're going to have your piece of jewelry. Everybody's happy. They get cash. You get the item. Well, plea bargaining would not exist unless the accused has some value. And that value comes from getting less than the maximum. That value comes from getting less than the maximum sentence. That's what we give up. And it's important that we have that ability so that we can be efficient, be economic, and meet the needs of the children and their caregivers and the parties to the prosecution. Because the system is so clogged. So you have efficiency, economy, right? And the last thing that makes plea bargaining indispensable to the criminal justice system is certainty. Certainty. Now, going back to emotional economy for a second, the defendant feels the same way. Every week that the defendant's hauled into court, there's the potential for bad things to happen. I told you how victims and their families feel every time they get that notice, every 6 weeks, for 2 years, 3 years, right? Well, think about the defendant. At least the victim and the family, we tell them to stay home. He's got to sit in the courtroom. Or he's got to sit in the jailhouse. He's one of 19 or 20 or 23 cases on the calendar that day. And any day could be his day. He doesn't know whether his case is going to get called. Think about the heartbeats that happen there. Think about the emotions for that defendant as he comes into court and sits there with all the other defendants who are on the calendar. All the other defendants who are brought over to the courthouse in a secure van and left in the basement of the courthouse in a jail cell and then brought up to talk to their lawyers. His case could be today's case. And nothing good happens in a courtroom for a defendant. At best, maybe he gets to go home. So, there's an interest for him, right? There's an interest for him in settling this, in stopping the madness, in stopping the process. Nothing worse than having this hanging over your head for 2 years, 3 years. Kids and the accused have a mutual interest in finality. Finality, efficiency and economy, those are the big three. Finality, efficiency and economy, and the last one, certainty. Certainty. I consider efficiency, economy the same thing, or related concepts. That's why I say there's three. Finality, it's over. Efficiency and economy costs less money if you resolve the case. There's less trauma for everybody if you resolve the case. And certainty, the courthouse, the criminal courts, the civil courts, all courtrooms, but especially the criminal courts, are uncertain places. Nobody knows the outcome. No matter how strong the evidence is, there could be a not guilty. No matter how weak the evidence is, there could be a guilty. No one knows the outcome. I've been around long enough to realize that I don't care what the facts are. I don't care how good the case seems or how bad the case seems. No one knows what the jury's going to do. I told you about that poor woman from from New York City, who was accosted by those police officers in Lower Manhattan. Casey Anthony, everybody thought was going to be convicted. I really didn't think the evidence was that strong there, but the average person thought it was such a great case. Obviously, the O.J. case, the evidence was overwhelming. Not guilty. Casey Anthony, not guilty. These police officers, not guilty. And then there's cases that are weak and lousy. Guilty. I've won my fair share of cases where I thought I had a lousy case. I did everything in my power to plea bargain that case. Couldn't do it. Got convictions. Tried cases where I thought I had the best evidence in the world. Not guilty. So there's uncertainty in the courtroom. And look, it doesn't happen all the time. Usually you can figure out whether it's a good case or not. Usually you can figure out how a jury might react to the case, but you never know. It's an uncertain place. So what does plea bargaining bring? Certainty. You know what the outcome is. No, he's not getting 10, but he's getting 4. I know it, you know it, he knows it, everybody knows it. There's something in it for him. If he loses, he's looking at 10. The victim, if he wins and the victim loses, so to speak, he gets nothing. So now we got 4, and everybody knows what they're getting. And a bad guy goes to jail for 4 years. And the victim may feel a little bit better. Maybe there's justice because he went to jail for 4 years. And he feels a little bit better because he knows on a 4-year sentence maybe he can get out in 1 year and 9 months. Or maybe 2 years. He knows what the outcome is. The victim knows what the outcome is. And that's a good thing. And the government knows what the outcome is. And there's a punishment. So finality, efficiency, and certainty. These are the things that make plea bargaining endure. Any questions about plea bargaining?
Who decides on how many years of a break they get instead of 10 before? The judge?
No. Now, the judge has the power if he or she thinks the plea is too hard, well, not so harsh, but too lenient. Because they can always give less than what the prosecutor recommends. So if it's too harsh, the prosecutor says, all right, this is a 20-year sentence, we're going to give 18. The judge is not going to go, well, that's too harsh. I think you should give him 12. He can just simply sentence him to 12 years. But if the prosecutor says, all right, it's a 20-year case, I'm going to give 6 months, the judge could not accept the plea bargain as being too lenient. But That very rarely happens. Your question was, who makes the decision? It's the prosecutor, in consultation with the victim and in consultation with their supervisors. They make the decision about what to offer.
Is there ever a case, or is there ever any type of case where it's completely off the table? Plea bargain.
Is there ever any kind of case where there's no plea bargain or it's off the table? Yes, there are cases like that that come up from time to time. It's very rare. Because there's uncertainty. But if it is particularly heinous and the evidence is particularly compelling and the guy deserves the maximum sentence, then you might not offer a plea bargain. It's very rare because evidence is not always as persuasive as you might think. But sometimes there's videos these days, sometimes there's stuff that's indisputable that you might go forward. But even now, we do a lot of these cases, the Sheriff's Department does a lot of these cases, we prosecute a lot of them, where men, mostly men, are online and chatting with, 8th grade and 7th grade girls, trying to meet them to have sex. And it's usually an undercover police officer. It's an undercover operation that many jurisdictions do. And, in those cases, they're nearly impossible to win if you're the accused. You can say, well, it was my 12-year-old son who was doing it, or your wife, you can blame them, but the computer comes back to some guy's house, and they usually tell personal facts about themselves. I mean, the cases are overwhelming. We have cases where the person manufactures child pornography, where they molest children and record it, and they're in the video. There ain't got to be a plea bargain here. But even in those cases, the courts are like, well, these trials, even, it could take months, and the juries, one of the cases, there may have been a plea bargain recently in our county where there was a lot of concern about the jury looking at this stuff. In other words, if he was facing 100 years, we didn't give much to him, but if he was facing 100 years, we might have given him 40 years. Because one of the concerns was being able to present this case. To present this case and convict this man, you had to show the jury, and he could force us to show the jury, hours of adult men having sex with babies and 4-year-olds and children, pre-pubertal children having sexual acts with one another. You got to show that. You can't win the case by saying, well, trust me, I saw it. You got to play it. And it's so despicable, so vile, that despite the fact that that case is nearly a slam dunk, nearly impossible to lose by the prosecution if you can tie the evidence to him, and if he's looking at the camera, he's got no defense. But there's another issue there, presenting it. Do we need to present that kind of evidence in a civilized forum like a jury trial? How about that? Or was it worth shaving a few? There was a woman once. Now, you say, well, this is plea bargaining. There's all these reasons why. I try to emphatically tell you why it's important. I did have a case once where I could not convince the victim to accept the plea bargain. In 20 years of prosecuting and more, I was able to make a persuasive argument that this was the right outcome to victims. So one time we have a case where a woman who was in a small town in Passaic County, she would come out to her car. She was a school teacher. And she would go to church. She was single, lived alone, and went to church on Sunday. And she came out to her car, and there was a note under the windshield wiper. And it said the most vile things about what this stalker was going to do to her. Graphic sexual terms, sadomasochism, despicable, unfathomable sex acts. She brings it to the police. She brings it to the detective bureau. And they really couldn't solve it. Her father was a retired FBI agent. And he really couldn't do anything for her. It got to the point where, for a number of Sundays in a row, over the course of a year or year and a half, she would get these notes periodically. And she was terrorized, to say the least. She wouldn't even sleep in her own home anymore. She slept in her father's home on the floor, then she went back home. And when I met her, she had stopped sleeping. She says, I don't sleep anymore. I'm always up. I'm afraid. Well, we had a lot of strategies. Somehow somebody knew somebody and they referred the case with the local, because this is as impactful as it was on the victim, this is a police case, not a prosecutor's office case. We don't have the stalking unit. They weren't in a relationship. It was just some case that would go to the police. And somebody knew somebody. They asked whether we would take a look at it. We brought it over to my unit. And we thought about options. We can put surreptitious cameras out there without talking about those things. When you have probable cause, we can record things. Now nearly everything's recorded, but this was 12 years ago, 15 years ago. We would have had to get an order. We could have put all kind of cameras in the vicinity of where she lived, surreptitious hidden cameras. We thought about that and a bunch of other strategies. But we lucked out. We got one of the letters, sent it to the FBI, and we got a partial print. Just old school. This could have happened in the 1920s. And it came back to a grave digger from Totowa, New Jersey. Some 50-year-old barrel-chested simpleton who actually dug graves. And interestingly, her senses got so acute in the end. And the most terrifying act of all was when he came to her home. And she got up too late, and the car took off. But she was able to see it briefly. It said it was like an old gangster car. It was a big, two-tone kind of car, and had she really couldn't describe it that well, but said it was kind of like a big gangster-type car. And she remembers hearing his feet. And he had heavy feet, probably wore boots. It was just a heavy kind of feel to the footsteps she heard. This was before she was able to get to the window and he had fled. But she remembers hearing those footsteps, and by the time she put two and two together and figured out that somebody's near her home and the car had left. But she remembered the sound of the heavy footsteps and suggested that maybe, sure enough, the gravedigger wore big lace-up work boots. Sure enough, he had one of these 19 circa, let's see, maybe early 1980s Cadillac Seville. They made a Cadillac Seville that kind of looked like a gangster car for a while. It was long and had harsh angles. And sure enough, he had that car, which was consistent with her description. Well, then we got a search warrant. It was all over. We got stacks of sadomasochistic pornography. And the guy was so simple, we got memo pads where he wrote in the memo pads. He wrote with the pen so hard that if you held the paper up to the light, you see, I'm going to come and kill you. And the guy was in prison for rape. So when we searched his home, we found none of the letters were there, but you could hold the memo pads up to the light on an angle, and you could see that when you press in a checkbook real hard, you could see your last check, the imprint of the pen pressure. Now, these were only 18-month jail sentences. I indicted him for, there was a new statute, they since repealed it, but it was harassment. I indicted him for harassment, but I also indicted him because it was a third-degree offense. Trying to get a little creative here. I indicted him for harassing someone based upon their gender. Now, that statute was designed for people who specifically target women because they're women and make misogynistic kind of statements to harass them about their being a man or a woman, in most cases a woman. And I said, hey man, what he said to her can only happen to a woman. You can only do this to a woman. He didn't do this to a man, he did it to a woman, and he talked about doing all these vile things to her woman parts. He harassed her because she's a woman. And maybe that's a stretch, and maybe it don't fit. Let's go to a jury. You know, I'm charging him with it. That gives me 5 years rather than 18 months. I'm charging him with it. I'm going to charge him with that offense. Let him go to Supreme Court. Say it doesn't apply. It was a little bit of a stretch, but I could make it with a straight face. I believed in it. They never tapped it. I talked to her. I said, listen, here's what I think we should do. Guy's never getting out on bail. Let's leave him in jail for a couple of years. By the time this case comes up for trial, it'll be 3 years from now. Then we'll put him on probation for 5 years. Because if we plead him now, he'll get 5 years, he'll be out in 2 years. And then he'll be under the supervision of parole. And I can't influence parole. They're in Trenton. You know, I'm not as confident that they're going to do what's necessary to keep an eye on this guy as I am if you put him on Passaic County probation. Same thing, probation, parole, they both supervise the guy who's on the streets who did something wrong. But parole is a state entity, probation is a local Passaic County entity. I have more influence, more relationships with probation. I said, the outcome's the same. He's going to do 3 years no matter what, however you slice it. So let him do 3 years and let him say, no, I'm not doing that. He needs to plead guilty for what he did. And he needs to go to jail for what he did. I go, but he will be in a sense. It's 3 years, it's 3 years. But he won't know it. He'll think he got over it. I don't want that. I want him to plead guilty for what he did, and I want him to do the maximum sentence. I said, well, you need to think about that. I don't know that I'm going to do that. I'm going to do what's right for the case. I know it might make you feel better, but this is the state of New Jersey versus this guy. I want you to think about it some more, and I'll think about it some more. And I thought about it some more, and I said, you know what? I'm going to do what she says. 99% of the time, I do what I think is right, and ultimately I think it's going to protect society better, or keep a better eye on this guy, but you know what? She's competent. She's bright. She's articulate. It's her case. I told him no plea bargain. Let's go to trial. You know what he did? Pled guilty to the indictment. He just pled guilty. He didn't want a trial. So it ultimately worked out. He just pled guilty to whatever I charged him when he pled guilty. He said, I want to plead guilty. And his lawyer pled him guilty. And he wound up getting 5 with 2.5 mandatory minimum. It was the only place that there wasn't a plea bargain in all these years. And what a liberating day for her, as you can imagine. The day we locked him up, you know, it was as if a 1 million pound weight was lifted off her shoulders. And she was no longer afraid of him because she knew what she was dealing with. He was a sad, pathetic simpleton. And he got arrested in the 1960s for making an obscene phone call, and they took his fingerprints. That's how he got caught. Because of those prints 40 years ago. Any other questions? One of the other things you have to understand in Roger Reddin's case or anybody else's case is something called PTI, or pretrial intervention. Pretrial intervention. We call this diversion. If you think about the criminal justice system as a timeline, or you think about it sequentially, guy does a crime, guy's arrested, guy has an arraignment, guy goes to grand jury, guy goes to trial, maybe a conviction, maybe not a conviction, right? Things happen in a sequence or order. Again, arrest, arraignment, grand jury, trial. Diversion diverts you from that process. It takes you out of the criminal justice process. The diversion in New Jersey is called pretrial intervention. And as the name implies, pre-trial, before there's a trial, there's an intervention. There's a resolution. The case is resolved. It's different from plea bargaining because you don't have to admit you're guilty. Essentially, you say, I don't want to go to trial. I did or didn't do this, whatever you want to say. But I'm willing to do probation. So your case gets pulled out of the criminal justice system. You're placed on probation for up to 3 years, and you may have to have certain conditions. Anger management, drug and alcohol rules, Alcohol Anonymous, Narcotics Anonymous, stay out of bars, no computers, all those kinds of conditions that are routine in the criminal justice system are fair game for pretrial intervention. It could be anywhere between 6 months and 3 years. Here's the rub. If you complete your 1-year pretrial intervention and you do all that's required of you, at the end of that time, the charges that existed upon arrest are dismissed as if they never happened. So you've never been adjudicated, you've never been convicted, you can go fill out an application to be the mayor of Washington, D.C. I've never been convicted of a crime, because you have not. There's no conviction, there's no adjudication. Your case is just plucked out of the criminal justice system and say, you know what, this is a minor offense. It drains too much of our resources. I know you say you didn't do it, or you only did half of it, or you only did 3/4 of it. You need to do this. Do it well for a year, and we'll drop the charges. It has to be a minor offense. And you could not or cannot have had a prior pretrial intervention. You only get one in a lifetime. Now, for drug offenses, there's something called a conditional discharge. It is kind of pretrial intervention for drug offenses. Now, technically, you can only have one or the other. You can't get a conditional discharge for drugs and then later do a burglary and get a PTI. Technically, you're only entitled to one diversion in your life, but many people get both. You get a free pass twice. You're not supposed to, but it happens. I was involved in a charity basketball game here a couple months ago, and we have a lot of the students, undergrads, are part of the rec department here. They were refereeing the games. One of the kids came up to me and he's like, I got caught with this, that, or the other thing down in South Jersey. And we debated the potential for a conditional discharge. I think he took the conditional discharge. Actually, he may have taken a complete dismissal. Because the first thing they do with a small amount of drugs is ask you to provide information about some other person. And there you get a complete pass. As long as you give them somebody bigger. You don't have to be, the head of the Gambino family. It's just, whoever you bought your weed from, give them, the case goes away. They get him, her, his case goes away. Until they run out of connections and then somebody pays. But in the absence of that, you can get a conditional discharge for drug offenses. Certain amounts of drugs. You can't have a kilo of cocaine. It's personal use kind of drug offenses, small amounts. Again, it's diverted. It doesn't get adjudicated. There's no finding. There's no guilt or innocence. You do some probation, and conditional discharges are very rote. They're very mechanical. You have to do drug testing. You have to do this, that, and the other thing. Almost always it involves routine drug testing. And once you complete that, those charges are dismissed. So that's another potential outcome in the criminal justice system. So, one of the other big things, one of the other peculiar aspects of criminal trials and criminal prosecutions involves bail. I suggest it's peculiar because whether you sit in jail or not depends upon whether you can pay the court. Why should justice, we talk about things seeming commercial or mercantile or having to do with dollars and cents. I mean, whether you sit in jail or not depends upon whether you can pay the court a quantity of money. That sounds terrible. So if you got money, you can go home. If you don't have money, you got to sit in jail. Well, that's an issue. You listen to that NPR, National Public Radio podcast that I asked you to listen to in Learning Module 2, you'll see the impact it has on the poor. The case I have there is called State versus Johnson. It's up on the big board. State versus Johnson was a case that was decided some years ago in New Jersey, and it interpreted the New Jersey Constitution, and it addressed the purpose of bail in the state. Now, before we get to State versus Johnson, in New Jersey, as it stands right now, the purpose of bail is to make sure that people show up for what? For trial, for court. It's the only purpose of bail. It's not for pretrial detention. It's not designed to punish. It's not because we think he's a creepy guy or a bad guy. It's simply an insurance deposit to make sure you show up for court. The assumption being you're going to come back because you want to get your money back. Bail is refundable 100% unless you go to a private vendor, a person who makes money by putting up the bail for other people. They're called bail bonds. But bail is 100% refundable. Just show up for trial and you get it back. Even if you're found guilty. Your wife, or your girlfriend, or your kids, or whomever goes and gets your money back. Case is over. Go get the money back. Many times it's the lawyer who gets the money. So in evaluating whether somebody's going to show up for an event, in evaluating whether somebody's going to show up for trial, or whether they're going to flee, and that's what the purpose of bail is, to make sure they show up for trial, and the legal analysis is based upon what we call the likelihood of flight, whether they're going to run away or not. If they're going to run away, or we think they're going to run away, we got to have a higher bail. If they're probably not going to run away, we have a lower bail. Bail is to create an economic incentive to stick around. The only issue is the likelihood of flight. Imagine one of your classmates wanted to borrow $1,000 from you. Imagine you had $1,000 to lend. Now, you know this classmate simply from this class. You don't know them from where they live. They seem nice enough. You've had a cup of coffee with them on more than one occasion. You might even have things in common with them, but they want to borrow $1,000 from you. You might understand their predicament. They may explain why they want to borrow $1,000. And you're like, I really want to lend them $1,000. But let's say you're going to be formal about it. And they accept that. Say, listen, I'm going to lend you $1,000, but I need to know the answer to some questions, and I need to find out a little bit about your personal life. What kind of questions would you want answers to if you're going to lend them $1,000? Go ahead. Do you have a job? Do they have the ability to pay? Right? And having a job also tells us something about whether they're productive members of society, right? People who don't work are perceived as, unless they're disabled. They're not too reliable if they're sitting around all day watching judge shows and doctor shows. Is there anything else on in the daytime? Judges and doctors it's turned into. Talk shows. Talk shows, judges. I think the judges outnumber everybody, actually. The judges have taken over. Doctors are behind, and the talk shows are up there still, but not much. The doctors. I don't know where these it's like, these horror movies in Hollywood, or even these television shows that have forensic pathologists. They're supermodels. I've seen a lot of forensic pathologists, Godspeed to them, but I've not seen very many supermodels who go into forensic pathology. But on TV, in the world of TV, they are. This doctor show, you seen this doctor show? 6'3", blue-eyed, supermodel men. All these doctors. I haven't seen doctors like that. Maybe they're out there. I haven't run into them. The judges look like us. They're cool. So anyway, you want to know if they have a job, or they're hanging around watching these shows all day. What else would you want to know about them?
Their address.
What's that?
Their address.
And where they live, and what might their address tell you? If they're living in a hut, or a trailer, or they're living in a mansion, might that be relevant to whether you want to give them $1,000? Well, let me put it this way. If they are of little economic means, and with all due respect to people who live in trailers, but if a trailer is an economic way to live, if somebody lives in a trailer that's all banged up and it's about to be repossessed, or somebody lives in a mansion, who are you more likely to lend $1,000 to? The person who's got the ability to pay, right? So the person who has a job, has property, valuable property, right? More likely, nobody's saying anybody's good or bad. It's purely an economic decision. I got two people standing here. The person who didn't have a nickel and ain't working, and somebody who's working and lives in a mansion. I'm going to give them the $1,000. Take my word. I'm sure you will too. What else would you want to know? What do you need it for? Okay, what else? When are you going to get the money back? Well, you want to make sure that they're reliable, right? What would you want? How would you determine if they're reliable? That's part of paying it back. How long they've had their job? What about their past? What does TRW and Equifax make $100 million a year doing? To check credit, right? So how do you determine whether somebody's creditworthy? What do you look at? What do they look at? History, right? Wouldn't you want to know whether they borrowed money before and whether they paid it back? Seems reasonable, right? If they borrowed money before and were late in paying it back or never paid it back, wouldn't that affect your decision to lend them money? I think so, right? So their past history in borrowing and paying back money is relevant. Would it be nice to talk to people who know them? I mean, this is a hypothetical, right? Your friend would probably go, I don't even want your money, man. You're going to bother my mother or my brother, But I'm saying ideally, you go talk to somebody who knows them well, say, what kind of person are they? Listen, Joe, they're okay, man. They're having a little trouble now. Look, they will do anything to pay you back. Or, one time, I don't want to talk bad, but, they've had problems their whole lives, Wouldn't it be nice to get a little bit of information about them? Somebody might sponsor them or embrace them or speak nice about them. Might that help you decide whether to give them money? Fair enough? What else? Anything else you might want to know about them or their situation?
They were ever charged with some criminal activities?
If they ever committed a crime. Actually, that would be a nice thing to know if you're going to lend them money, right? Because why? Somebody who commits a crime compared to somebody who's never been in trouble, who's arguably more reliable and more honest and more trustworthy, right? The person who's never committed an offense, or the person who knew that it was wrong to burgle, to steal, or to commit fraud, or to punch somebody in the nose, and they did it anyway. Now, in fact, they might be equally responsible, but we're making an analysis here. The guy or gal who's committed a crime has thumbed their nose at society, right? They violated a rule. Well, rule breakers are not the kind of people I want to lend money to. Now, look, we can put that, well, it was a barroom fight when they were teenagers. Well, we can put that in context. But they're starting out with a problem, in my book, if I'm going to lend them $1,000. I don't want a person to have my $1,000 who commits crimes. I mean, it doesn't seem like a responsible person. I want to know more about that. In the end, we may be able to put that in context, but compared to somebody who's never committed a crime, they're less reliable because they've already demonstrated that they're rule breakers. They broke the law, for Pete's sake. So yes, that's a very good thing we want to know about. Let's put it to bail now. Likelihood of flight. Aren't these things very similar to the things you would want to know about whether somebody's going to stick around or run? If they're charged with burglary, aggravated assault, and theft, and we'll throw in criminal sexual contact, they're charged with all these offenses. And they say, Judge, I didn't do these things. I did not do these crimes. I want to be out on bail until the trial. Well, we need to find out about this person, right? We need to find out where they live. Do they have a house? Or do they rent? Nothing wrong with renters. I rent it. It's not about renters. It's about ties to the community. Likelihood of flight. The next buzzword is ties to the community. You got a loan from a bank. You put your blood, sweat, and tears into a home, or a condo, or a townhouse. Right? You own it. You own a little piece of the earth in Passaic County. It's a little harder for you to run to California or Texas or Mexico or the Republic of Ireland or Algiers. Wherever people who flee may go these days. It's a little harder to flee when you own a piece of the land here, right? You got nothing, you got nothing. You got something, it's a little harder to run away. So the law looks at ties to the community. Whether you own a house or you rent a house. Prior history where? Prior history on bail. Some guys have been on bail before. Works both ways. If they did good on bail and they showed up in court on multiple occasions, that might say, well, they did good on bail. On the other hand, if they did lousy on bail, or if they didn't show up at their last trial and the government had to go track them down, then they're going to have a very high bail now. Prior track record, we call that. Prior record on supervision. So do they have any connections to the community? Have they been convicted of a crime? Same rule breaker analysis, right? Who's more likely to show up? The person with no criminal record or the guy who's got multiple convictions? Who cares most about honoring your promise? And that's why the $1,000 analogy is an apt one. Because they're both about honoring your promise to show up. What would we want to know? The bail guy? Wouldn't it be nice if his pastor came in or his wife or somebody who knew him well and said, listen, Judge, he's not going to run. I can vouch for him. That's not going to end the inquiry, but it's better than the guy who's got nobody who vouches for them. Well, who are you, sir? Well, I'm Father McGillicuddy. I've been at the St. Anthony's Parish Church for 75 years, and I know young John since he's a little boy. I know his mother, I know his grandparents. He's not going anywhere, Your Honor. Is the judge going, oh, let's give him a party and let him go? No, but that guy's going to do better than somebody who has nobody. So all of these things go into the analysis, right? You know, high bail, low bail. Roots in the community. That also shows he has roots in the community. Father McGillicuddy knows him since he's a little kid. So how long you live there. Whether you have a prior criminal record. Whether somebody will sponsor or speak up for you. Whether you have a mental disability. You know, if you have a mental disability, you might not understand that you got to show up. You might be more likely to flee. There might need to be better supervision if you are let out. Whether they've committed any crimes. Whether they own real property. whether they have family here. You know, if your mother, your sister, your brother, your grandparents, Father McGillicuddy, you're all here, if you're going to run to Algiers or Texas or wherever, Mexico, you're leaving it all out behind. It's a lot harder to flee from everything and everybody. What's left? You give up it all. You give it all up. It's not that easy. So a person who's got all those roots, all those connections, is less likely to run. It's as simple as that. On the other hand, somebody who's in Passaic County with no family, they've only been here a couple of months. In the past 3 years, they lived in Galveston, Texas, Atlantic City, New Jersey, Catskill Mountains, Portland, Washington, San Diego, California. Oh, 3 years, they've been all over the country. They got no roots, Your Honor. You're not going to stick around, you're going to run. The likelihood of flight is significant. The guy has no connections to this area. Now, that guy may stay. Doesn't mean he's going to leave, but he's a high risk. The higher the risk, the more money you got to put down. That's how bail works. Any questions or observations? I'm going to let you hear. Now, when I say a prior criminal record, any criminal record demonstrates that there is a lack of respect for society and the law. But some crimes are more important and are more relevant in a bail analysis than other crimes. What kinds of crimes would be even more important and more likely to result in a higher bail, be more relevant to the judge's analysis than, let's say, a burglary or a shooting or an aggravated assault? Murder is a very serious crime, and that may get to a different issue, that is the seriousness of the crime. Certainly the seriousness of the crime, although we don't put people in jail and make their bail high because we don't want them to commit new crimes, but the more serious the crime, the more likely to flee. It's as simple as that. Why? Because if you're facing murder charges, you can face life in prison without parole. So if I know I'm facing life in prison without parole, then I'm more likely to run. If the charge is 4th degree harassment or defacing a stop sign, I'm going to run. I'm going to leave all my stuff here and go move to Algiers because I'm facing a year and a half in jail. So the more serious the crime, the more serious the punishment, the more likely a person is going to flee. Does that make sense? Okay. Related to that is the quality of the state's case. Where the prosecutor has great evidence, where there's a video of their crime. Judge, his face is in the video. He's molesting children. There's no way out. The state's case is very good, Judge. The quality of the proofs, is what we often say, is outstanding. So if I know the state's got a great case, I'm more likely to run. Listen, I'm not going to beat this. They got a video of me. I know the outcome. I'm going to jail. There's no way to beat this. I'm going to take off. So the stronger the case, the more likely someone's going to flee. You may be charged with murder, but you have a video of yourself at the Los Angeles Dodgers San Diego Padre game. You're like, I'm not running. I got video that proves I didn't do this. Why would I run? So you can have a serious crime, but weak proof. But when you have a serious crime and strong proofs, the bail's going to be higher. You can have a less serious crime but strong proofs, the bail's going to be a little bit. So all these things interact with one another. Quality of the case, seriousness of the crime, ties to the community, relatives, sponsors, mental status, and the crimes that I was talking about were crimes of truthfulness, right? It's one thing to be a burglar or someone who punched somebody. It's another thing to commit welfare fraud or false swearing, perjury. What's perjury? Lying in court, raising your right hand and telling the jury and the judge you're going to tell the truth, and you don't. Well, this is about promising to be somewhere, man. You committed the most significant offense against the judicial system you can imagine. Lying to the court. False checks, false swearing, forgery, welfare fraud, fraud of any kind. These are more powerful prior offenses, right? This doesn't only show a disrespect for society's norms, like crimes do, right? This shows you're a liar. You are a liar. When it comes to crunch time, you will lie. And you've lied to get money. You've lied to get advantage in this society. Well, that person's going to have a tough time getting a reasonable bail. The bail's going to be sky high. Now I'm going to play a bail. I made a bail argument on a guy who kidnapped his own son. It's a parental abduction case. And while I don't spell it all out, you can hear in his history. And the reason is the judge knows what I'm talking about. I'm before the presiding criminal judge, and I don't need to say, in judge, we all know that somebody who deserts the army or commits forgery is less likely to tell the truth. I mean, those things are implied here. So I don't make the kind of precise arguments that I'm suggesting to you about a bail analysis, but you will see that this guy is a high risk on bail when I make the argument. And his lawyer makes the argument as well. You'll be able to hear it in a minute. This is not important. Don't worry about it.
Good morning, Judge. Joseph Del Russo for the Passaic County Prosecutor.
Okay. This is going to be status conference by a bail motion.
I'm going to jump ahead. There's a lot of stuff in the beginning here that's not relevant.
Mr. Furman does have a prior record, but it is rather remote. I think it goes back. I have it with my notes here. That he has a 91.
This is his lawyer arguing that he should have a reasonable bail. I'll back it up a little bit, but he's talking about he does have a prior record, but it's remote. It's a long time ago. And that's important. I mean, if you committed an offense a month ago, or you committed an offense when you were in college 30 years ago, it would be weighed differently, right? So that's what his lawyer is trying to argue. I'll back up a little.
Apparently in making motions, and that is with the defendant's prerogative, but I'm not going to keep this plea offer open indefinitely. I'll talk to Mr. Palazzo and, we'll come to an understanding about how long it's open.
All right. With respect to the bail motion.
I'm sorry?
You have a bail motion?
Yes, sir. I heard this case from Mr. Lopez of Canada County before he resigned. I believe he just filed a previous bail motion. Mr. Furman does have a prior record, but it is rather remote. I think it goes back. I have it with my notes here. That he has a 91 conviction out of Virginia. There were 2 DTs out of New York, 94, 96. There was something from the United States Navy. I think it had to do with his conviction out of Virginia because there's no disposition indicated on that. But it is a rather remote record. Mr. Furman is gainfully employed. He is an eligible contractor by trade. He was working at the time of the arrest when he was fine work on the streets. The $200,000 bail is prohibited at this time. No economics from our organization. The charge was asking for a low bail to allow Mr. Furman to make his bail and further assist me with this case. It's much easier for him to assist me on the outside, especially reviewing the records, which are getting more and more voluminous as the case goes along in our institutional investigation. So I would ask for honor to lower his bail at this time. Thank you.
Judge, we believe the bail is appropriate at $200,000 and there should be no reduction. This case involves second-degree offenses for which there is a presumption of incarceration. Further, the defendant has a prior criminal history, which makes it likely that he will receive the upper end of any sentence should he go to jury trial and be convicted. So the stakes are high for this defendant. More importantly, I would suggest, Your Honor, that the quality of the case is good as well. Mr. Furman had a relationship with the mother who was the alleged victim in this case, and the mother of Ishan. And on the day that
name, sir?
On the day that there was,
And don't interrupt, you can
Sorry.
say, that's all right, you can say something at the end if you wish to.
on the day that the child went missing, there was an act of domestic violence in New Jersey, and the defendant made it clear he was taking the child and would not return him. For weeks and weeks after that, the victim in this case attempted to make contact with the defendant and was unsuccessful. She went to seek relief from the courts of Passaic County and was given relief by Judge Freed. And the defendant played a game of cat and mouse with this woman. I would suggest the evidence will show quite compellingly. In fact, because he used cellular phones and text messaging, there's a digital trail that shows how he was tormenting this woman and stated on multiple occasions she will not see her kid again, as well as making threats. More importantly, he got into a text message discussion with Captain Norton of Wanacue Police where he told him that he needs to come to the police station and straighten this out. He said he was going to seek asylum or made some statements and non sequiturs to Captain Norton. And then after that, in a discussion that was recorded on a police line, he was told by Detective Kathy Carmen about Judge Freed's order, and he had to return the child, and it was ignored. He was eventually, as Your Honor may recall,
I believe I signed CPWs in this matter.
yes, Judge, as Your Honor may recall, yes, they're in discovery, and after we got the CPWs, that allowed us to track his movements and eventually arrest him in suburban Indiana. So I would suggest because of the recordings and because of the text messages that have been documented and anyone can look at, the quality of the proofs are good. More importantly, I think one needs to look at one's prior history, and I don't think the prior history of this defendant reflects favorably on his application for bail. Whatever the explanation or the ultimate outcome, these are the charges as I read them. Desertion from the United States Navy, attempted robbery, criminal contempt, bail jumping, and possession of forged instruments. Now, some of these matters may have been downgraded, some of them may have been overstated, but in looking at the whole person and making a decision about whether this defendant ought to be at liberty on these serious offenses pending trial, I think that the evidence suggests that the bail ought to remain the same, and that these kinds of offenses suggest a lack of cooperation with the courts and a lack of credibility when it comes to making representations to other people, specifically the courts in New Jersey and Virginia.
Mayor, as Ms. Del Russo alluded to some tapes that were the water.
Okay, the other attorney starts talking about discovery issues, not bail, after I was heard. But you could see in this case with this defendant, the attorney for the defense argued that he has a job. When he was out, he had a job, and that would be a root in the community. His job, by the way, was in New York City. He lived in New York City at the time. And I don't know that he was even working. I didn't even address that. He was an electrical contractor. I don't believe he was working at the time. But nevertheless, he did work as an electrician. And he also said that those convictions were remote, that they happened some time ago. And I didn't address when they occurred. I addressed two things: the quality of the case and those prior convictions, which you couldn't get a better batch of prior convictions to argue that somebody ought to be kept in jail or have a significantly high bail. You wouldn't argue that they be kept in jail because that's unconstitutional, but that their bail be high and significant. The quality of the case, he was terrorizing his paramour, his girlfriend, the mother of his child, by text messaging and leaving voicemails and sending MMSs with pictures of the boy and calling her the most vile names and threatening to kill the boy. I mean, the case is strong. You know, all I got to do is put on a big screen in front of the jury and show these text messages. They were outrageous. And look at the convictions. Desertion. Was it forgery, I think I said? Forgery. And what was it doesn't get any better than this for a prosecutor. What was the one?
Jumping bail.
Bail jumping. I mean, The guy was on bail already once, and he jumped bail, which means that he violated the terms of bail. Needless to say, the bail was kept at $200,000, and he stayed in jail until we resolved it. But that's the way it goes. The defense makes an argument, the prosecutor makes an argument. There are far more details that are relevant than we talked about, but remember, the court has an entire package of information on their desk that's been prepared for them. When we go before the court, the lawyers, we simply highlight the things that we think are most important. And in the case I have on the big screen, you have the case of State versus Johnson. That's the case you read for class. And that case is the leading case on the issue of bail. Go ahead.
What does seeking asylum mean?
Yeah, I'm not sure what he was talking about, but he's an American citizen. He lived in New York City. When the police officer was telling him, you have to come back, we need to straighten this out, he started saying bad things about the police, and you're out to get me. I know my rights. I'm going to seek asylum. I've been persecuted. I'm not sure what he meant. That's why I called it a non sequitur. I don't know what he was talking about. Asylum typically is when you live outside of the U.S., in a country where you are politically oppressed and your life's in danger because of your political beliefs or your honest beliefs, because you're a woman or you're a minority. So if you stay in your country, you'll be harmed or killed. You come to the U.S. and say, I want asylum. I want safety. I want to come to America because I'm in danger where I live. So I don't know what he was talking about. It was nonsense. In this case, State versus Johnson, the court outlined the things we talked about on the last page. The seriousness of the offense, okay? The defendant's criminal record, reputation, mental condition, how long he lived in the community, family ties, employment. So be familiar with that. And it goes through the entire history of bail. Interestingly, I put in your announcement page a video clip from yesterday, which I'll play a moment of. Governor Christie came on television yesterday in a press conference, and he said the following.
Good morning. Thanks for coming. Last month, during the State of the State message, I made a promise to a mother from Newark that we would help to reduce the cycle of violence so prevalent in many of our urban communities. Today, I'm proud to stand here with the Attorney General, with a number of county prosecutors from across the state to propose changes in our bail process with a constitutional amendment that modifies the right to bail in New Jersey, one that works to enhance overall public safety while securing the integrity of our criminal justice system. The change, which parallels the federal system, aims to provide our courts with the ability to keep dangerous offenders in jail and off community streets, rather than giving them an opportunity to commit further acts of violence, intimidate witnesses until the time of their trial. A 2007 study by the Bureau of Justice Statistics found that of pretrial releases, about a third of released defendants were charged with one or more types of pretrial misconduct. Nearly a quarter had a bench warrant issued for failing to appear in court, and about a sixth were arrested for a new offense. More than half of those new arrests were for felonies. Making changes to our bail laws is a common sense move to stop preventable crimes from occurring by allowing a judge to use his or her common sense approach to deciding whether someone deserves to be released or not. Their history of crime and the potential danger to individuals, both witnesses and innocent citizens on the streets, should be one of those factors that a judge should be able to consider. This revision establishes an exception authorizing pretrial detention when a court finds that no amount of bail, pretrial release conditions, or combination of bail and conditions would assure the defendant's appearance, protect the safety of any person and of the community, or maintain the integrity of the criminal justice process. This long overdue common sense measure can only improve the quality of life in our communities by keeping the most violent criminals off the streets and ease the minds of folks around the state against those who have been charged with violent crimes.
So, this was yesterday. I edited it and put it up there. This is not the law now. The only way to make this happen is to amend the New Jersey Constitution, not the federal Constitution. The federal law allows this. But New Jersey says that everyone has a right to bail, if you read that Johnson case again, unless it's a capital case, unless the death penalty applies. There's no such thing as pretrial detention for public safety in New Jersey. Governor Christie is proposing that the Constitution be amended, he said this yesterday, and that it permit pretrial detention, where, as he expressed it, no amount of bail can keep the people in society safe. Now, I think he's talking about gang violence and things like that, where people have unlimited resources or virtually unlimited resources. They can get out and go out and intimidate witnesses and undermine their own case by scaring people. It's a big problem. Pretrial detention is abhorred by academics and by civil libertarians. I think there's going to be a tough road to hoe for this. I'm not sure what's going to happen in the end. It requires that the Constitution be changed. It's a lot easier to change the New Jersey Constitution than the federal Constitution, though. A lot easier. But it still requires, I think, a supermajority in the legislature, and I think it requires public referendum, but it's a lot easier than the federal Constitution. So this is not the law. The only issue right now is whether the guy's going to show up for court, not how bad he is. There's no pretrial detention in this state. Any questions? All right. I mentioned earlier probation and parole, and I'm not going to get too much into those concepts. Suffice it to say that both are forms of supervision after someone's convicted. If someone's convicted of a crime, they can be placed on probation instead of jail. Probation is supervision instead of jail. Parole is supervision after jail. So parole means you served a portion of your sentence and you are released into the community transitionally. Thus, you will be monitored and supervised for a period of time. So probation is supervision before jail, instead of jail, and parole is supervision after jail, after a state prison sentence. Now, probation, parole, and even bail can all have conditions attached to it. If you're going to be out on bail and at liberty when you're accused of a crime, the court can make sure that you do certain things. Same thing with parole and probation. All three forms of supervision, bail supervision, probation supervision, and parole supervision, permit any reasonable condition. Any reasonable condition. Some examples: no contact with the victim, no contact with the victim's parents, get an AIDS test, you're not allowed to use computers, you have to have your urine checked for substance abuse once a month, twice a week, whatever it requires. If there's a history of drug or alcohol abuse, you're placed on what they call D&A rules, D and A rules, drug and alcohol rules, drug and alcohol rules. You must maintain employment. You must stay out of high crime areas. You must continue your schooling if you were in school. You're not allowed out at night. You're not allowed in bars. Whatever's relevant to your offense. You can't go on the internet. You can't have a computer. You can't have a mobile phone that has web access. You have to wear a bracelet around your ankle. All of these things are among the many reasonable conditions of probation and parole that can be imposed by a court. And bail. There's an article that you read called The Cultural Defense and Its Irrelevancy in Child Protection Law. I would suggest that the cultural defense is irrelevant in the criminal law, at least when it comes to guilt or innocence. It may be relevant in mitigation. Which means that it may be relevant in what your punishment is. And if you came from a country where what you did is the norm, or it's even sanctioned, or at the very least it's not illegal, then that may result in a lesser sentence or a more understanding outcome by the court. But the author of this article in the Boston College Law Journal, Todd Taylor, argues that it's irrelevant in child protection law. And the reason is, and this is a good time for you to learn the fundamental difference between the criminal law and child protection law. The criminal law is designed primarily to punish. The big three are punishment, incapacitate, and deter. Punish, incapacitate, and deter. That is the purpose of the criminal justice system. To hold people responsible for their bad behavior. To incapacitate, to get them off the street so they can't hurt other people. That's incapacitation. When you put them in a jail cell, they can't hurt other people. And deterrence is to deter them and others from committing the same or a similar offense. These are the general justifications for sentencing for criminal offenses. And the sentence that a person receives goes up or down based upon what I call the blameworthiness of an offense. Somebody who puts graffiti on a stop sign is less morally blameworthy, less of a bad person, to use that informal characterization, than someone who kills somebody or someone who burns someone's house down. The more blameworthy, the more morally repugnant to the average person the behavior is, the more significant the sentence is going to be, the higher the punishment. Similarly, if there's something that impacts upon that blameworthiness, like mental illness or immaturity, you're going to get less of a sentence or no sentence. So someone who murders someone or burns a house down where people die, who is substantially mentally impaired and suffering from a mental illness where they have no conception of what they're doing and they have no idea that what they did is wrong. In fact, they believed they were setting fire to a house in which Satan lived. Now let's assume we believe all that. They're not blameworthy. It's terrible what happened, but the criminal law is based upon punishing people who are responsible for their behavior. Now, like you, I don't want that guy in the streets, but he's not blameworthy, right? So that's the number one issue in the criminal justice system, is culpability or responsibility. And that determines what your sentence is. And when it's time to sentence someone, the purpose is to punish you. Society wants retribution. That's another one. To give you four of them: retribution, punishment, incapacitation, and deterrence. These are the big traditional reasons for sentencing in America. Punishment is a form of retribution. The idea is society feels better if they know bad guys go to jail. Makes me feel better. It may not make me any safer. It may not deter him. It may not result in less crime. But society's got a right to feel better. That's retribution. We feel better to get a little revenge. And we're due that. Society is entitled to that. That's one theory. Punishment is related to that. Punishment. Bad guys ought to get punished. It also rewards people for following rules. Right? It gives us an incentive to do the right thing if we know that bad guys get punished, that people will be held accountable. So punishment and retribution are important. Incapacitation is important. I know that this guy won't rape or kill or burn houses down because he's in jail. He's incapacitated. And lastly, deterrence. When he gets out, this is called specific deterrence. Specifically, that guy is going to think twice before he burns a house down again with people in it, if he even gets out. Or he's going to think twice about kidnapping his own child and terrorizing his paramour or girlfriend. He's going to be deterred from doing the same crime because he had to go to jail for a while. Right? That's specific deterrence. General deterrence is when everybody else reads about his case and goes, man, I'm not going to kidnap my own kid. That guy wound up with $200,000 bail, went to jail for 5 years. I don't care how mad I get at my wife. I'm not going to do that. That's deterring everybody else. Specific and general deterrence. One reason why you see high-profile prosecutions of celebrities, especially for tax evasion and insider trading. What's her name? The woman who's the Martha Stewart, Al Sharpton, David Dinkins, Willie Nelson, the dude from Survivor, Richard Hatch, I think his name was, first Survivor winner, tax evasion. You or I, same offense, they may settle, they may not even go to criminal, you pay them back. I mean, you're in deep trouble, but you're not going to prison. Both insider trading and tax evasion happen all the time. It is epidemic, and there's no way for the government to stop it. People cheat on their taxes, and people trade on insider information every day. It's impossible for the government to stop. There's no way to make it go away, other than to scare people and to make them think they're going to get caught. The odds are astronomical that you will get caught. But the government wants to put the fear in you that you will. So when they catch a celebrity, that's very good publicity, and publicity is deterrence. If you follow the stock market, let's say on Friday they're going to announce Procter & Gamble just bought Pringles today, I think. I read online. Kellogg bought Pringles? Okay, Kellogg bought Pringles, but they're owned by somebody. Kellogg's just the name of the cereal. I think Procter & Gamble is General Mills. Let's Google it. Pringles. Pringles. We'll go to news. Oh, I stand corrected. Kellogg. But Kellogg is a... where's news? Kellogg is a... belongs to somebody. Kellogg offers $2.7 billion as a video. Owns Kellogg. Anyway, the point is, let's say it's Kellogg. It doesn't really matter. Kellogg bought Pringles today, right? Now let's say Pringles was trading for... what's today, Wednesday? It was trading for $8 a share on Monday. They didn't announce it till today sometime. We can look that up. I guarantee you that Pringles stock went up yesterday. Guaranteed, significantly. That cannot happen without insider trading, right? Why would anybody be interested in buying Pringles? Why would there be a lot of volume? Why would Pringles move from $8 to $11? I'm making stuff up. I didn't look it up, but I guarantee you if you look it up, it will have gone up. Because there's insider trading all the time. So when what's her name? Martha Stewart, insider trades, there were other people too, famous people insider traded. They're going to be made an example of. And it works. It keeps most of us, if not nearly all of us, honest. Because it acts as a deterrence. One of the most obvious example of deterrence is, when I was younger, people drank and drove all the time. It was just as dangerous then. Driving under the influence was a serious offense, but not like now. Now the consequences are dramatic. Crazy dramatic. Jail, lose your license, you get stigmatized. 1980s, you got caught drinking and driving, it was not a big deal. Then the Mothers Against Drunk Driving made it their business to change the law and to make the consequences more severe. Most people don't drink and drive anymore. The Mothers Against Drunk Driving led to the initiation of drunk buses in Belmar. The Jersey Shore has drunk buses. You know what a drunk bus is? You stand in front of your house on 10th Avenue and they'll pick you up and drive you to Bar A. And you could drink till you're, ossified and they'll drive you home. There were no drunk buses in the 80s. You drove to Bar A. I'm not saying I did it, but that's what people did. But guess what? Why don't people do it anymore? The consequences are dramatic. That's an example of deterrence. Deterrence works. I'm a big believer in deterrence. Now, it can only deter people who care. If you're morally bankrupt, then the criminal law has no value. It doesn't matter to you. But most people are good people, and most people don't want to get in trouble. And that's what works. However, back to the cultural defense and its irrelevancy in child protection law. The purpose of DIFAS and child protection isn't to punish. It's to keep kids safe. A woman could be the nicest mom, the best mom in the world, but she was brutally gang raped by members of a street gang. So badly traumatized that she has flashbacks day and night. She can't even get out of bed during the day. She can't feed her kids. She can't put her clothes on her children. Her kids have stopped going to school. She's a mess. Is she at fault? Is she a bad woman? No. She was gang raped, for Pete's sake. But she can't care for her kids. Neglect is neglect is neglect, and we don't give a damn whether you meant it or not. You understand? So whether someone is blameworthy is irrelevant in child protection law. It doesn't matter. What matters is risk of harm. So if you came from a country, where children of age 7 are allowed to drive tractors and cars on the Garden State Parkway type highways, it doesn't matter. You put your kid at risk by letting him drive a car at age 7 on the Garden State Parkway. I don't care how good he is at it. I don't care what they did in your country. It's neglect, and it's dangerous. Now, how child protection intervenes is another thing. They don't have to take away your kids because of that, but you need to be spoken to. There needs to be an intervention. You need to appreciate what the cultural norms are in the U.S. Right? The defense that this is what happens in my country is irrelevant to a child protection analysis as a matter of law, as a matter of common sense, right? I posted for you, and it could easily be the subject of a discussion board, although I didn't make it one. In the Cyber Cafe, I posted a recent example which references another case from '97. I called it Cultural Defense Let Sleeping Babies Lie. Both of them involve Swedish women who tethered their infant children to something, a parking meter or sign, and went shopping. One went in and had a cocktail in 1997. This lady went in and this is last couple months ago. She went in to buy something in a store.
Oh, yeah, in France they do that place.
Yeah, they do. It's not exciting.
She went into the restaurant to get something to eat, I think. Swedish woman who police said left her baby unattended outside a Massachusetts restaurant while she ordered food inside was called into child protection. It was a 1-year-old boy in a stroller. In 1997, there was international debate about this case where a Danish woman, now this is Swedish, this was a woman from the Netherlands, was arrested after leaving an infant on a New York City sidewalk to go into a restaurant for a drink. Now, she could have went in for Coca-Cola or Cosmopolitan, I don't know. Either way, she's drinking something. She's out there spending time having a drink. And, which I found offensive here. I didn't know this. A federal jury in Manhattan later rejected her claim that the police had falsely arrested her. She was arrested by the police. This is the Danish mother in '97 who went and had a drink, left the infant outside. But the jury gave her $66,000 in compensatory and punitive damages following the ordeal. That's offensive to me. It really is. Look, would it mitigate her? Did she tie her kid outside to go deal crack? Or did she tie her kid outside and not come back for 20 hours or come back a month later? No. Is that perhaps a cultural norm? And from everything I read, it is. Sweden? I mean, look, that's a very different country than New York City.
Yeah.
Yeah. I guess if you're walking down the street in Copenhagen, you're dodging strollers and baby chairs, baby seats.
Like my being in the restaurant, whatever, having dinner, the kids.
And I accept that. I accept that. That's what we're talking about here, the cultural defense. But I think child protection needs to get called, man. I don't know that. I don't know if she's from Sweden. Why should she get $66,000? Child protection should be called, and she should be held accountable, and she should have been arrested. It's just not part of our cultural norms. Now, ultimately, she needs to be understood. Even in the child protection court, even in family court, and in the criminal courts. What I hear all the time in my profession is, And my Latino friends tell me, this is the answer to that. In my country, it's okay to have sex with 12-year-old girls. Where I come from, it's okay. We have arranged marriages. We get married. And some of that may be true. But you got to check it. You know, my advice to young prosecutors is, first of all, you know, the defense lawyer walks in like you heard that bit. You know, Judge, my guy's accused, but you know, in his country, this is part of the societal norms, and you know, older men and younger women are embraced where he lives. It's okay where they live, and you know, my first advice is check it out first. In my case, it was a Peruvian defendant. I called up my friend who was born and raised in Peru, went to college in Peru, came to grad school in the U.S. I said, Juan. He goes, no way, man. This is a 12-year-old girl. She was a 6th grader and a 32-year-old man. He goes, no way. He goes, look, in the mountainous region, do some people do that? But our nation does not accept that. We don't encourage that. That's not encouraged in Peru at all. You know, he said, it's like America. If you go to some parts of the Deep South, people do things, or some parts of, you know, does that mean it's okay? Because that's the way they were raised in Appalachia or in West Virginia or something? And with due respect to them, you know, that don't make it okay. Just because it happens in America and in some enclaves and some small groups in America that this kind of stuff happens more often than in other groups? No. He goes, our country doesn't endorse that. Now, old 14-year-old kids, there's other places you'll see, I don't know, it's this class. I think in forensic interviewing we do this kind of cultural thing where we ask questions about dating and relationships between younger women and older men and vice versa. You know, we typically have responses, not so much from the Caribbean, but from Equatorial Africa, where you have arranged marriages in some cultures where 14, 15 is, you know, but even there, it's arranged. There's people involved. It's not some nefarious thing where a 32-year-old man's, you know, on the sly having sex with a, you know, 8th grader. The families are involved. It's part of a more sophisticated and formal process of uniting a post-pubertal girl and a man in marriage. While it may be criminal in America, it's certainly one can understand that other nations have that kind of cultural viewpoint. You don't see that in the cases I get. It's usually it's not like that. So I've yet to see a cultural defense that was persuasive to me. They can make it in the criminal law, and ignorance of the law is not an excuse. It doesn't matter in most cases. But on sentence day, it's relevant. I don't, you know, if this lady was convicted from Denmark. On sentence day, I don't even, she shouldn't do a day in jail. You know, if that's I understand that. First of all, I would want to find out more about her, how long she's been here, how long she's walked down. Did she just come off the boat or the plane 10 minutes ago? I'd be more understanding. You know, I'd be more understanding. If she's been here for a couple of years and lives in Manhattan, I'm not buying it. And that's why I tell prosecutors, scratch the surface here. Don't buy it. Now, if she did, if she just came in, if she just was visiting her relatives, she had the baby with her, she walks down the street, everybody seems so nice, you know, all right, that lady probably doesn't even need any intervention. I'm not so sure until I ask, until I find out. I need facts. The newspapers just like to paint it with broad brushes because it's sexy and it's interesting. That's why in your next discussion board, if you didn't do it already, I have a video clip where you get into Michael Vick's, the now all-pro quarterback for the Philadelphia Eagles, his conviction for dogfighting, when he expresses the reason why he didn't think it was a
You thought it was a cultural thing.
Did you do this?
Yeah.
Oh, okay. There you go. So you guys are ready. I'm looking forward to reading your perspectives about that. One of the discussion boards I read that was not on Michael Vick's, not understanding of Michael Vick. And I'm not so not. He was interviewed by James Brown. I thought it was a nice interview. I think he was putting it in context. It's not a defense. It's just terrible what he did. And I'm a dog lover. I'd throw myself in front of a train for a dog rather than a human. I mean, he electrocuted them. He did vile and terrible things to them. But I know he was explaining what happened. I mean, I know why he did it now. I still find him reprehensible for doing it. One of the students was going, are you kidding me? This guy went to Virginia Tech University. It's not like he lived in the backwoods his whole life. He graduated from a premier university in America. He knew what the hell he was doing. I mean, this didn't happen when he was 12. He was a multi-millionaire who created a whole sophisticated dog torture building. Reprehensible. Anyway, that ends it for today. I will see you next week. I will post a lecture online.